woman. Hello, everyone. Welcome to this basic training module on legal aspects of open source, in which we are going to explore open licenses. The open source movement is a collaborative approach to creating and sharing software, hardware, or data where the source code, designs, or informations are made freely available for anyone to use, modify, and distribute. At its core, the open source philosophy emphasizes the idea that when people work together openly and share their work, innovation can happen very quickly and at a rapid pace. Instead of proprietary closed-off development, where the inner workings of a program or device are kept secret, open source encourages transparency, collaboration, and community-driven development. Open source projects typically use licenses that ensure that software, hardware, or data remains open. There are various types of open source licenses, such as the new General Public License, GPL, EUPL license, CERN Open Hardware License, and many others. Understanding licenses is crucial for anyone working with open source projects, whether you are a developer, contributor, user, or a business entity. Licenses define the terms under which the open source software, hardware, or data can be used, modified, and distributed. They provide so-called legal framework that ensures the project remains open, and they also govern how others can interact with it. Understanding licenses in open source, however, requires not only knowing licenses, but also understanding the basis of intellectual property. So in this course, we are going to explain different intellectual property rights that can be embedded in an open source project, and then explain the basis of licensing in open source. After the completion of this course, you should be able to understand and explain the main rules that regard licensing in open source projects. So, open, we can also call it free source, is a historical concept extending far beyond modern times. Prior to the 15th century, intellectual property goods resided freely in the public domain. There were no intellectual property rights. The concept of granting exclusive rights was developed later on. However, nowadays, it is gradually not declining, but changing its scope, especially in open source projects. So traditional models of knowledge creation and dissemination with intellectual property rights and with the right to exclude are no longer the solely options, especially not in open source projects. Intellectual creations in open source projects may be used by anyone without the special permission of the rights holder of those creations. This is because the rights holder waived the restrictions to use that work. It means that he operates them under an open or free license. Open or free source license means that a content like an artistic work, a computer program, a technical solution, or any other innovation can be shared, studied, used, and changed in a non-exclusive way. This does not mean, however, that everything is allowed. Open source licenses come with specific obligations and conditions that users, developers, and contributors must adhere to. Failure to comply to those obligations can lead to legal issues and infringement of intellectual property rights. And so they are the object of a license, and we are going to discuss them a little bit further. Open intellectual property rights safeguard creations of the mind, such as inventions, literary works, and symbols. The key types of intellectual property rights include patents, which provide protection to inventors for new inventions or processes. They include copyrights, which protect original works of authorship. Then we have trademarks, which identify and distinguish goods or services in the marketplace, and trade secrets that protect confidential information. These basic intellectual property rights are described in the upcoming slides that get definition of a certain intellectual property right, benefits, some description on the procedure, how to obtain those rights, and so on. I invite you to explore these intellectual property rights on your own, because a solid understanding of these foundational types of intellectual property rights is very important to understand the rest of this lecture. So with open source projects, one may encounter a blend of these rights. Software is primarily protected by copyright. However, it can be also protected by a patent or by a trademark. Open hardware projects, which include design files, schematics, and other documentation, can be copyright protected. The code written for the hardware is also subject to copyright. And if the open hardware project includes novelties, inventions, processes, or other functionalities, it can be eligible for patent protection or protection with a utility model. If the hardware has a unique visual appearance, it can be also protected by design rights. Hardware can also be protected by trademark in order to establish brand recognition. Open data, finally, can be protected by copyright or by a database right. In order to use those rights, open software, hardware, and data are released with open licenses. They outline the terms under which one party, the licensee, is allowed to use intellectual property owned by another party, the licensor. The purpose of a license is to give the licensee certain rights to use the intellectual property without transferring ownership of the intellectual property. Actually, a license defines how the intellectual property can be used, such as for manufacturing, distribution, sale, or other specific purposes. Licensing terms define the scope and limitations of using licensed intellectual property. In the following slides, the basic licensing terms are explained. Please read them carefully. Let's move on to the categories of open source licenses. So, open source licenses can be classified as reciprocal and non-reciprocal, permissive, and copyleft. Permissive licenses grant maximum freedoms to use, modify, and distribute open source solutions with minimal obligations. Examples of permissive licenses include MIT license, Apache, and BSD licenses. Permissive licenses allow for wide use with just a few restrictions, and also derivative works can remain proprietary. On the other hand, copyleft licenses require that all derivative works be distributed under the same license. Examples of copyleft licenses include the New General Public License, GPL, New Lesser General Public License, LGPL, and Mozilla Public License. What is the difference between copyleft and permissive licenses? Copyleft licenses ensure that derivative works remain open source, and they promote a culture of sharing and collaboration. On the other hand, they impose strict requirements on distributing derivative works, and they potentially limit commercial use and integration into proprietary software. Permissive licenses allow for a greater flexibility in how the software can be used and integrated into proprietary projects. However, they may lead to the loss of some control over the software's future and modifications. Open source licenses can also be classified as reciprocal and non-reciprocal. Historically, the concept of license reciprocity has been understood as synonym of copyleft. Permissive licenses are non-reciprocal, and copyleft licenses are reciprocal. Reciprocity refers to controlling improvements of work and ensuring equal rights to all users in accordance with the licensing terms. Choosing the right license for an open source project is crucial, as it can significantly impact the project's success, adoption, and sustainability. The license clarifies what users are allowed to do with the software, hardware, or data, ensuring that everyone understands their rights and obligations. Some licenses, like permissive licenses, MIT, BCD, allow for greater freedom in how the project is used, modified, and distributed. Others, like copyleft licenses, GPL, ensure that derivative works also remain open source. Choosing an incompatible or poorly understood license can lead to legal issues and result in legal disputes. To avoid them, please listen to the advanced legal module on legal aspects of open source, in which we are going to explore open licenses in details. So, thank you for listening to this basic legal module on open licensing, and please feel free to explore some other materials in our project. Thank you.
Go.